Okay, welcome everybody. Thank you so much for joining us today. Um, my name is Alicia Post. We appreciate you being here for this important program. I'm the executive director of the RZA. The RZA, or the Religious Zionists of America, Mizrachi, is a movement that strives to build a strong bridge between Israel and the American Jewish community, support the state of Israel, and ensure that American Jews are connected to and taking responsibility for the state of Israel and the future of the Jewish people. RZA is not affiliated with any political party here in the United States nor in Israel. As you may notice, you are muted, but I do encourage you to ask questions in the chat, and we will try to get to as many as time permits at the end of the presentation. Additionally, you may notice that this meeting is being recorded. It is on the record and it will be available for viewing. We will send it out to all of you who have registered, and we will also post it on our YouTube channel. I now have the honor and privilege of turning this over to RZA's president, Stephen Plato, who is joining us from Jerusalem.
Thanks, Alicia. Hi, everybody. We're going to be welcoming our esteemed guest speaker, member of the Knesset, Simcha Rothman, as soon as he gets in front of his computer. And we're excited to have him. As you may know, Mr. Rothman is a member of the Religious Zionism Party, and as Alicia said before, not affiliated with the RZA in America in any way. He is the chair of the Constitution, Law, and Justice Committee, and a co-chair of the Land of Israel caucus. In his first Knesset term, Mr. Rothman was a member of the Judicial Selection Committee. Before he was elected to the Knesset, he was the founder and legal advisor of the Movement for Governability and Democracy, Meshulut, which is a leading voice in the fight against judicial activism and for proper separation of powers in Israel. Being a lawyer by training, he researched the complex relations between appointed and elected officials and represented Meshulat in appeals before the Israeli Supreme Court and in various Knesset committees. Mr. Rothman is the author of two best-selling books. His first book, Supreme Rulers, How Israel Became a Legalocracy, in 2019, made the Israeli public aware of the problems with judicial activism. His second book, Why Should the People Elect the Judges, in 2023, calls for a change in the Judicial Selection Committee in Israel. Mr. Rothman earned his LLM in public law in a joint program with Northwestern University and Tel Aviv University. His LLB, his law degree, he obtained from Bar-Ilan University. He studied also at Yeshiva Keren B'Yavne and served as a chaplain in the Combat Engineering Corps of the Israeli Defense Forces. I want to welcome Minister Rothman.
Hello, shalom, shalom. Shalom.
Hello.
Thank you so much for being here with us today.
Yes, I can hear you.
Okay, good. Good.
Okay, so as the Zoom states, we're going to be discussing law and judicial review. If you want to maybe give us a briefing, Stephen, do you want to ask any specific questions?
No, I'd like to hear from Mr. Rothman where we are today. I mean, I'm in Jerusalem. You know, as an American, as an Ola Chadash, I have found the Israeli legal system to be very different than what I grew up with in the United States. People say there's a separation of powers in Israel, but I really don't see that as a separation of powers between three equal and co-branches of government. I agree with many who have said that the Supreme Court has acted as a legislature, as opposed to being simply a place for judicial review. And I know, Mr. Rothman, that you have been in the forefront And I think we'd like to hear in America exactly what what you're struggling for, we're struggling for as Israeli citizens here.
Okay, so thank you, and thank you for the warm introduction and this opportunity to speak to all those important people. Let's talk a little bit about powers, separation of powers, and the main differences. I believe most of the people here know the American system to some extent. Um, between the Israeli system and the American system. Now, of course, the United States is an empire, and as an empire, the people from the empire think that the way that they are doing things, that's the common way. Um, Actually, when you see the common law systems or the Anglo-American heritage of systems, the United States is quite unique. It's not the regular way of conducting constitutional business, if you will. The UK, Great Britain, does not have a written constitution at all. The court can never do judicial review over legislation, only over acts of government. It actually can do judicial review to some extent by saying that the court thinks that some legislation is incompatible with constitutional values, but it has no effect of canceling the laws. The parliament, it's a system of parliamentarian supremacy, just like New Zealand, the same idea, just like Canada had until the 80s when they adopted the charter. And even after adopting the charter, which is their constitution, every province, the equivalent of a state in the United States, every province can override with a simple majority a decision of the Supreme Court of Canada canceling legislation because of a problem of consistency with the charter. So the U.S. is quite unique in the English-speaking countries that the United States have a very robust constitution with three equal branches, as you said, with equal power that derive their authority from the Constitution. And to change or amend the Constitution, it's extremely hard. That's not the case. Also, if you compare what's happening in the United States to what's happening in Europe, with other kinds of constitution, also a different story. The Constitutional Court is elected in a very political way, not with life tenure most of the time. It's different. It's different. Israel was started as a country with the British system of parliamentarian supremacy. We don't believe in Israel, again, just like the UK, just like New Zealand, with a court that derives its power from a constitution and is equal to the parliament. Our courts operate and regulated by laws that we in the Knesset legislate. We tell the courts, we're supposed to tell the courts, what kind of courts exist, what are their powers, and what is not within their power. We in the parliament. Why? Because we're in a parliamentarian supremacy system. That's the way Israel started. That's the way Ben Gurion intended to and said it explicitly. This is the way the court recognized its powers for decades from the beginning of the State of Israel until 1995. Until 1995, where the State of Israel almost celebrates its 50 years anniversary, the court said, we have the power of judicial review to legislation. despite the fact that the Knesset had never given the court this power. And this has created basically a constitutional crisis that we are in this constitutional crisis since then. Ups and downs and more important issues and less important issues, but that's the case. And this is why when we appointed our judges, the system, the mechanism of judicial appointments was not so important. Why? Because the court was very, very weak institution. They were professionals dealing with judicial review over executive branch actions and other branches and deciding disputes. They did not have interfered most of the time with politics. They did not interfere in legislation in any way. And that's why the fact that the system is not so democratic in the way we appoint our judges, it's not like in the United States where the president appoints, the Senate confirms. Our system to this day is a committee of 9 in which elected officials, coalition and opposition, are the minority, are 4 members out of the 9. And the majority is sitting Supreme Court judges, 3 members, and 2 members of the bar. So, and it did not bother many people. And the Chief Justice, Landoy, when he saw that the court under Aaron Barak leadership is moving into judicial review and canceling legislation and interfering with politics and policy, he wrote and he said, you're creating a monster. You are creating a problem for the court because the legislator will not sit back and see the court stealing his powers and not interfere in our judicial appointment mechanism. Because he will say, if the question is not what the law is, but the question is who is the judge, then I want to decide who is the judge. And that's exactly what happened. And that's why one of the major aspects of the judicial reforms that Minister Yariv Levin proposed is to change the way Israel selected judges, to make it a little bit more like the American system. We did not go all the way because we're conservatives. We do not believe in revolutions. We try to change as little as needed in order to make the Israeli system understand the ideas of checks and balances and democracy and rule of law. But we have to make sure that the elected officials of the state of Israel can have an effect on how we select our judges. And this is why another key aspect of the reform was that the court will not be able to cancel government actions because of their reasonableness. Meaning, if the court wants to do a judicial review over government actions, by all means, we all believe it's needed. We need it in order to have separation of powers, and we need it to have freedoms and rights, and we needed to have make sure that the executive branch is respecting the rule of law. It's important, but it has to be when the executive is going against a law or against human rights. It cannot be based on the fact that the court looks at the decision and say, I don't like it. I think it's unreasonable. I think I would take another path. That's not judicial review, that's judicial tyranny. And this is why we canceled the reasonableness clause. I will just finish with this part to answer your question. I think the most recent and and emphasize. Example, we just got with the head of the Shin Bet, with Ronen Bar. No one in the world, there is no court in the world that if a government have a vote and decides to remove the head of the Shin Bet from office and appoint someone else, and some Joe Schmo without any connection to the issue will go to the Supreme Court and say, this is unreasonable. I don't think you need to fire him. I'm not even talking about the fact that we're talking about the head of a Shin Bet who failed miserably on October 7th, and there is no debate on this, even he admits it. But the fact that the court, A, accepted this appeal to begin with, B, did not kick it out, C, held a hearing, and D, gave a decision that told the government, wait, don't get rid of this guy, shows you, and there is no written law that allows it, and the law says specifically that the government is able to remove him from office. It says it in the law, very clear, and it also makes sense. It's a separation of power, and it's within the government discretion to make sure that the Israeli security is being kept. Everything, it's the perfect storm. And the fact that this case is still pending decision in the Supreme Court tells you the entire story. In Israel, we don't have checks and balances. We have only checks, zero balance, and 100% judicial tyranny.
How do you respond to critics who worry that the changes would undermine, and their phrase is, judicial independence and put too much hands in the power of politicians?
Again, most democratic countries that I know of appoint their judges in a system that is 100% political. 100%. The United States, some states, have an election. Some states have system like the federal system that the governor appoints and the state Senate approves. The federal system, the president appoints, the Senate approves. In Canada, that's the way it works. In most countries. In other countries, the parliament chooses. In some parliaments, the executive chooses. And sometimes the public chooses. And either you say that all those democratic countries do not have independent court, which is a strange declaration to make, or that you say that Am Chacham Venavon, a smart people like the Jewish people, are the only people in the world that are not smart enough and responsible enough to select their own judges. And they need to have it imposed on them by some judicial elites that will tell them who got close enough to God Almighty and is worthy to be a justice in the Supreme Court. I don't accept this view. And also, during the legislation, Professor Shitrit came to the committee. Professor Shitrit is a professor of law, and he is the writer and the coordinator of the Mount Scopus Rules of Judicial Independence. There is standards, international standards of how do you make independent court. And in those standards, it says specifically that selecting judges by the executive and selecting judges by the parliament does not have by itself any effect on judicial independence. As long as that once you appoint them, they are free to decide what they want, and you cannot kick them out of office easily, they are independent. President Trump appointed a lot of judges in his first time in office. He went to many, many judges and put in front of them a challenge to the elections. Not one of the judges that he himself appointed gave him what he wanted. So the fact that the system is political and the president appoints judicial appointees does not make them less independent. If you will, I think it makes them more, because they are accountable to the body politics, of the state, and not to one guy or two guys, Supreme Court justices, that they owe their appointment to.
So one of the things that I have tried to understand, and it befuddles me tremendously, is the entire electoral system. In Israel, we don't vote for Simcha Rothman. We vote,
Too bad.
for his list, for his party. A few weeks ago, my son, who lives here in Jerusalem, said to me, I'm having a problem with X, Y, and Z. And I said, why don't you call your elected representative? And he said to me, I don't have one. When I'm meeting with people from the communities that have been devastated by October 7th, they say to me, we went to the Knesset and they got nowhere, because there doesn't seem to be anybody that anyone can point to in their own community to say, you represent me, I need you to advance our cause. Is there any possibility that we would go to a direct election here in Israel by the creation of voting districts or seats? We have that, of course, in the United States. England has a slightly different arrangement. In America, you have to live in the jurisdiction that you're trying to represent. In England, apparently, members of parliament don't have to live in the seat that they are given. They just have to campaign there and get elected from there. Do you have any comment on the chances of actually having true legal reform here in Israel?
No, so electoral reform is one thing and legal reform is something else. And it's not directly connected. It has some connection, but not a lot. And I will answer first about the electoral reform, or the need of the reform that you are talking about. First, of course, in the beginning, it was 100% true. Now Israel got more populated, but there are some electoral districts in the United States that are larger than the state of Israel. So both in size and in population. So the fact that you have someone who represents your district, you can look at Israel and say, okay, so Israel is one big district, but and everyone knows everyone, and everyone connected to everyone. That's one thing. The second thing is that the electoral system with districts is very easy to manipulate in order to cancel minorities. And Israel is a country with a lot of minorities that the dangers of them being canceled will hurt exactly the same rights that people trying to say when they're objecting to the judicial reform in a non-justified way. Because Israel, because of its electoral system, does not need the court in order to defend minorities. Minorities in the Israeli system are getting over-representation and more power. Maybe you will see it as a problem, maybe you won't. As an Anglo, I would say, living in Israel, I would say maybe because there are Anglo communities in certain districts, maybe you'll have 2 or 3 Anglo representatives in the Knesset, but the rest of the country will not really care about the Anglo constituency. Why? Because you have your representative in one place. In no other places, you are basically minorities that can be ignored. So you will have 3, 4 representatives out of the 120, let's just say. Let's take it as an example. So you'll have 4, and that's it. Because we are in a party system, then the Anglo community, which is a small community compared to other communities maybe, can unite, can go and join different parties, and you can get representation and parties to care about your interests from 5 or 6 parties in the Knesset, because you have some Anglos that are more secular and they maybe will vote for Lieberman's party or Yesh Atid party, because and be there, and they'll have Anglo base that care about this. You will have Anglo Haredi, which will affect the Haredi parties. You will have Anglo Dati Leumi people that will affect religious Zionist party. You will have Anglos that will affect the Likud, and in fact, as a minority, you have an effect over 60 seats in the Knesset, 70 seats in the Knesset. Another example is the Druze community. The Druze community is very, very small in Israel, but they are very united and located in very specific places. If you will put district system, you probably will not have any Druze representative in the Knesset, because they're small, usually surrounded by Arabs, and the Arabs will cancel them out. But because they are unique in their way of thinking and their cooperation with the State of Israel and the alliance between them and the State of Israel and their Mesirat Nefesh for the State of Israel, then in the last Knesset, you had 4 representatives, Druze, 4 or 5 Druze representatives in the Knesset. That's way more, because every party competed on this constituency. So you would have a minority that usually, if you will do the district system, will have 0 or maybe 1 representative. Instead, they have 5, and all parties wants to help them. So it gives a lot more power to minorities, less ability to cancel out minorities, and it's a protector of rights. That's part of the reason that most of the rulings that the Supreme Court created based on equality, you would think it would be to defend minorities from the majority that wants to swallow them. But in reality, most of the rulings of the court on equality issues is actually against the minority of Haredim. And they say we need to defend, in the name of equality, the majority of the public of Israel from the minority of the Haredim. That's not a criticism that I make. I also make it, but it's not mine. This is a criticism that the Chief Justice Grunis wrote in his ruling. He said, we were given a power to go counter majoritarian power, and what we are doing is we're using it against minority. Are we crazy? My answer is yes, but okay.
I think it took me 3 years to realize that this was not a swear word in Israel. Like my granddaughter explained that to me. It just means patience, and that I think is the is the byword for everything I come across here as a citizen. I'd like to go back for 1 second. I don't think I really understand what a basic law is. Is it constitutional in nature? Is it something that can't be amended? Is it something that can't be changed or done away with? What exactly is a basic law in Israel?
Okay, so the Declaration of Independence that we all cherish, and I have it here. I don't. Yeah, I have it here on the wall. You don't see it because if I'll take off the the filter that makes it blur here, you see it. So you see it here.
Yes, yes.
The Declaration of Independence. So we all hold it dear, but and maybe it was a Greek philosopher who said that education is about lying to the people you educate. So the Declaration of Independence is a little bit based on lie. It starts with a lie and it ends with a lie. It starts with a lie. It says, "Be'eretz Yisrael kama Am Yehudi." So, as a person who believes in the Torah, I know that Am Yehudi left Egypt already as a nation. We got the Torah as a nation outside of Israel, and we came to Israel as a nation. So we did not start in Eretz Israel. We started in the desert. If you look at the Torah, we started in Egypt. Pick up. If I was more of a non-believer, I would say that the historical story is that what made the Jewish people is actually exile. We started looking at ourselves as Jews only the first time people were looking at Jews is Mordechai Yehudi in exile. Before that, no one would say HaYehudi. People said something else. So I don't know if Be'eretz Yisrael kama Am Yehudi. But it also ends with a lie because it says that in October 1948, there will be an election based on the constitution that will be made until October 1948 for the first representative body of the state with the constitution of Israel. Now, in October 1948, there were no elections and no constitution. And so this is, and the reason was that was the war, of course, 1948 war, but the question, but the first elections were held to the Founding Fathers Committee, which was called the Knesset, with 120 members that will write the Constitution of the State of Israel. But instead of writing the Constitution of the State of Israel, they became the legislator because they were the only elected entity in Israel at the time, and people have to run a country during a war. So all the powers of the temporary government was moved to the Knesset and to the government, and instead of founding fathers committee called the Knesset, we got a legislator called the Knesset. And the Knesset accepted the decision, it's called the Harari decision, saying we are not able to have a constitution, we are a country to run. What we will do, we will have a committee. The committee will be the Constitution Committee, which I am the chair of, a little bit, few years after. And this Constitution Committee will legislate basic laws that will be, when finished, chapters in the future Constitution of the State of Israel. And since then, we do basic law. And basic laws are just are being legislated just like any other law. There is no rule of how to do it. We just call it a basic law because we think it should be a chapter of the Constitution. It deals with constitutional issues. We think it's important enough to put in the Constitution of the future Constitution of the State of Israel. So basically, the Constitution of the State of Israel is work in progress. What is the Constitution today? So for many years, the idea of the court said a basic law is just like any other law until you make it into a constitution. And then in 1995, the court says, oh, the basic laws, two specific basic laws that I chose, they are semi-constitution, and I can cancel laws based on them. And after that, the court said, oh, there are some other basic laws that I can cancel laws about them, because of them. And since then, the court even says, no, there are even basic principles that only I know what they are, and I can cancel laws and basic laws based on them. So that's the situation today. So if the definition of basic law is a law that the Knesset chose to call basic law, and usually it deals with constitutional issues. And if you would ask me or a law professor 5 years ago, is basic law a constitution, meaning that gives the power of the court to judicial review based on basic laws? Some people would say yes. Now, after the court canceled basic laws, then this question is moot. You say the court does not take seriously even basic laws. The court basically say, I can cancel whatever law I see fit based on what I see fit. It's not about what's written in the basic law, yes or no. So basic laws and their supremacy over regular laws are questionable.
Okay, so we have a question from someone from RZA-Mizrachi. If you had the power to unilaterally change the judicial system in Israel, what would you do?
I would take away my power because I don't think any one person should have a unilaterally power to change a court system. But I would try to have a system that judges are appointed in a political way, just like the United States, with limited time in power, not lifetime tenure, but 12 years, 15 years, something along this line. So it will be long and independent, but not indefinite. And I would say that the court should have very strong gatekeepers to prevent cases without legal standing to arrive to the court, that the court will deal only with cases and controversies, just like in the United States, not in anything they want to talk about. It's not a Friday coffee shop parliament. It's a court, and that it should deal with issues of law and legal issues, and not with policy or other issues. And the court, that's the court. And I believe that when the court can have a limited power of judicial review, it has to be checked in a way that the final word must be at the hands of the Knesset and the elected officials. Even though if you let some kind of judicial review, that's about the court. Another problem that we did not touch at all is about the legal advisor and the chief legal advisor, Attorney General of the State of Israel, which is a whole different story of authority without any responsibility and accountability.
Okay, so we have a bunch of questions coming in. Okay. You referred to the ability of individuals or groups appealing to the court demanding a hearing. Why haven't proposals tried to limit access by responding true standing, like in the United States and England and elsewhere?
So I spoke about it a little bit now when someone asked me about the ideal justice system in my eyes. But there have been some attempts to do so. There's even a bill of legislation that I wrote. But the main problem is that in the countries that the person who asked the question referred to, like the UK or like the US, the issue of standing is not written in any law. It's being kept by the court in order, because the court limits itself, because the court does not want to get into certain issues. So it's a limit that is self-imposed. It's very hard to legislate some kind of restraint. It's very hard to legislate the common sense. It's almost impossible, because there will be always issues that the standing, even in the United States or the UK, that the question of standing is vague, and sometimes you can have standing and not have standing. It's a question. If you try to make it into a very strict formulated law, that you are missing out on issues that might need to get to the court, even though their standing is a little bit shaky. And if you do it left too open, then the court will have a lot more issues coming that the court can deny. It's very hard to do, and it needs the cooperation of the court. Currently, the court in Israel, even what you would call the conservative judges in any other country, would be called crazy, crazy, crazy act. If you would put all the judges in the United States on a scale between 1 and 10, when 1 is the most activist, progressive judge, and 10 is the most conservative judge, and you will try to say, okay, so where are the judges of Israel? Where is the most conservative judge in Israel? Again, I remind you, 10 is the most conservative guy in United States, and 1 is the most activist, progressive judge in the United States. Then the judges in Israel will start in minus 500, somewhere along this. This is where they start, minus 500 to minus 1,000. It's not even on the same scale. There is no judge in United States, no judge that would hear a case about Trump should not fire the head of the FBI. There is no judge who respects himself in the Supreme Court that will even hear this case. He will kick it out immediately and say, you don't have standing. Why do you think I should decide for the president who is the head of the FBI? And in Israel, we call this kind of appeals Monday or Tuesday or Wednesday or Thursday. It happens every day. So that's the main problem. It's very hard to legislate for people who don't really respect the letter of the law or the intent of the lawmaker.
Okay, I'd like to switch topics, if I may. Let's talk about society in Israel for a few minutes, if we can. I hear and I read Haredim don't want to do this and Haredim don't want to do that. They don't want to go into the IDF. And yet I've also heard from Haredim that we are making inroads. We are getting men into the IDF. We are getting people to become productive members of, let's call them the working society, which I've always thought was always the case anyway. How do we address what seems to be the outright opposition from Haredi leaders, and therefore it trickles down to the people in the street about opposing entry into the IDF. How do we deal with that as a society?
It should be a process. It's not something that happens overnight. And unless, of course, you don't want to do it and you want to have a fight, and then you try to do this overnight. Now the systems and the mechanism that will bridge the gap between the Haredi society and the IDF and the economy exist. But you have to make them stronger and not weaken them. And you might think you changed the subject, but it's actually the same subject. Because if you want to do something about the Haredi society, you need to do it with the cooperation with their elected officials. That's the democratic path to go. And the court in Israel prevents any compromise or a step towards the right direction in the last 20 or 30 years. You're talking about the draft issue. The Knesset legislated laws that were aimed to draft more and more Haredim into the army many times in the past. They worked, some of them. They got good numbers, some of them. They were all canceled by the court because it wasn't harsh enough. Now, I'm not even talking about legislation that was passed by Haredi parties. I'm talking even about the legislation that was passed when Haredim were not present in the coalition at all. And the coalition legislated against the Haredim, and for the court, it wasn't good enough. So if you can't have any solution that is gradual and a compromise that will bring numbers and will normalize Haredim going to the army. When I grew up in Bnei Brak, well, there were many Dati Leumi people in Bnei Brak, but I learned in the Haredi school for the first 8 years. After that, I went to Yeshiva Tichonit, but the school was Haredi school with most of the children coming from Dati Leumi houses. But the teachers, the Haredi teachers, most of them were serving in Miluim. It wasn't rare to have a soldier coming to the school, to the Haredi school. We even had Morim Chayalim, Haredim, on uniform. And the fight that the court has dragged the state of Israel to, the state of war between the Haredi society and the court and the IDF, first by canceling any legislation with gradual adoption, and second with closing down every path of service in the army because they did not get in girls. Okay, if you want to have Haredim in the army, you should have separate units. Otherwise, they won't come. But the court has canceled it and says, no, you have to bring the girls in. Okay, you bring the girls in. The Haredim won't come. What do you think will happen? And I was today in the security committee in the Knesset, and I showed them that there are 10 Hesder yeshivas for Haredim, that the only solutions that bring Haredim into the IDF, and due to a decision of the court and the decision of the legal advisor, they cut their budget 6 months ago. Now, these are the people that are getting Haredim. They know how to do it. And the court fights them. And the legal advisor fights them because they don't want the solutions. They want the fight.
So what does the future hold for us?
first we do judicial reform, and then we solve all other problems that the judges has caused for the state of Israel.
I hear what you're saying, and frankly, I have a new appreciation of the need for judicial reform. I never looked at it the way that you just said it. I think you did say that the Haredi draft law was not harsh enough. I think that was the word that you used to describe the Supreme Court ruling against the law. Speaking about Supreme Court and speaking about Haredim, let's talk about the topic that is on my head all the time living in Jerusalem. I'm getting tired of having to go to shelter from Houthi rockets. I was very glad to see that Israel reacted strongly in Sana'a by basically, sounds like destroying the airport. Why is Tehran off of our list of targets?
If I will tell you, I'll have to kill you now. But no, no. I think that Iran should be. I said it openly. It's not a question. I know that we are. It's not a secret that Israel is trying to work on this issue together with the United States. And United States, President Trump just said he wants to try negotiating first. So that's a reason to give it a chance. I believe for this United States, and I believe that the state of Israel is coordinating with it. Of course, Israel should never, and I believe have never, especially in this government, giving a veto power on the measures state of Israel needs to do in order to protect itself. So that's why we're seeing where Trump is leading the negotiation, and if the state of Israel will work to eliminate the nuclear program of Iran, I hope together with the United States, and if not, by itself.
But I see that Trump has, I'll use the word, he made a deal with the Houthis. Leave Americans alone, and we won't fire on you. And then they specifically came back and said that we are not giving up our support of the Palestinians in Gaza. So where does that leave Israel? Is Israel truly going to have to act on its own, or is this a wink and a nod?
Again, I don't. The attacks that the United States did in Yemen on the Houthi was started not because they shot at us. They shot at us way before. It started because they attacked American vessels, and they blocked trade routes near the Red Sea. This is the beginning. And if this attack by the United States had created safe passage in the trade routes and stopped the activity against ships near Yemen, I think that was the goal. The attacks of Yemen and Israel started way before. We need to respond to it by ourselves. Of course, we would appreciate every kind of help, and we're getting a lot of help, but it's not. I think that Israel must always be able to fight its own wars. We can be helped by our friends, the Americans. We can be helped by our friends. Everywhere we can get help, but the state of Israel must be independent in securing its own border and its own citizens from missiles, from rockets, from attacks like October 7th. We should be independent, and we should eliminate every threat to the state of Israel by ourselves.
Rothman, thank you. Thank you for representing the Dati Leumi community in Knesset. The information that we get in the States from Israel is not always what we want to hear. But I want to acknowledge that I'm glad you're there. And I want to say that we're all continuing here to pray for the release of the remaining hostages and their safe return home, and that we'll continue to bring more programs such as this. And I just want to, wish you and everybody who's been on the Zoom call, the Sorah Tovot. It's that phrase has become something that here in Jerusalem and Israel, we seem to be ending every one-on-one conversation with. So I want to wish you all a Shabbat Shalom from Jerusalem, the united capital and eternal capital of the state of Israel. And Mr. Rothman, you have especially a Shabbat Shalom
Thank you.
because you're in the front lines. And we're only here sitting back doing the best that we can.
Thank you, Shabbat Shalom, and thank you for this opportunity to speak to you. Thank you.
Hope to hear from you again in the future.